Welcome to This Explainer. We're diving into a high-stakes legal drama today to answer a truly massive constitutional question. Who actually holds the power to regulate? We're unpacking a landmark case from the Constitutional Court of South Africa, AAA Investments versus the Microfinance Regulatory Council. It's a fascinating story about money, power, and the blurry, almost invisible lines separating private companies from the actual government.
Okay, so let's get right to the fascinating question at the very heart of this case. When a government decides to outsource its regulatory duties to a private entity, does that private company suddenly have to play by the government's constitutional rules? It's a real blurring of the lines between corporate boardrooms and legislative chambers.
Here's our roadmap for This Explainer. We're going to start with the microlending boom, then look at enter the private regulator, move into the legal showdown, debate public or private power, discuss the power to delegate, and wrap up with the final verdict. So part 1, the microlending boom.
Let's rewind a bit. For decades, South Africa operated under the Usury Act of 1968, which puts super strict caps on interest rates to prevent loan sharking. Sounds good on paper, right? Well, it had a massive unintended consequence. Banks basically refused to lend to poorer people because, without a higher interest rate, the financial risk was just too high. So fast forward to 1992, and the minister uses a new power to grant an exemption for small loans. Lenders could now legally bypass those strict Usury Act caps. And boom, this unleashed an unprecedented, totally unregulated microlending gold rush.
But here's the dark side of that boom. This exponential growth came with a steep human cost. The industry absolutely surged because lenders could now rake in essentially limitless profits. Without strict rules in place, vulnerable borrowers were being severely exploited, getting trapped in these vicious debt cycles with astronomical finance charges. It got so bad that the government was forced to completely rethink its strategy. They just couldn't leave this market entirely unchecked anymore. Which brings us to part 2. Enter the private regulator. Okay, so it's 1999, and the minister steps in with a brand new exemption notice. This time, they capped eligible microloans at 10,000 Rand, payable over 36 months. Now, if a lender wanted to charge those lucrative high interest rates, they had to qualify for this specific exemption. But the minister threw in a major structural catch. Here is the absolute kicker. Lenders had to register with a newly created private company called the Microfinance Regulatory Council, or the MFRC. If you were a microlender, you literally had zero choice in the matter. You had to join this private company, pay their fees, and follow their rules. If you didn't, well, you were operating outside the exemption and suddenly facing severe criminal sanctions under the old Usury Act. Talk about strong-arming. Now here's where things got really heated. The MFRC didn't just enforce the minister's basic rules. No, they went ahead and wrote their own massive rulebook. While the minister was just asking for basic borrower protections like a 3-day cooling-off period, the MFRC mandated that lenders hand over all their confidential data to a mandatory national loans register. Plus, they started subjecting lenders to private disciplinary hearings and fines. This felt like a drastic overreach to lenders like AAA Investments. They were furious, arguing, hey, we never signed up to be governed by some unelected private corporation. And that leads us straight into part 3, the legal showdown. As the lawsuits started flying and the case moved up the judicial chain, the courts were totally split. The High Court completely agreed with the lenders. They basically looked at the MFRC and said, you are a government imposter exercising unauthorized public legislative power, so your rules are completely invalid. But then, the Supreme Court of Appeals stepped in and entirely flipped the script. They argued that the MFRC was just a private company. According to them, when a lender registers, they're just signing a private contract, so it's private power, making the rules perfectly valid. It's a complete 180. So now, the Constitutional Court has to break the tie in Part 4, public or private power. Justice Yaqub anchored the majority's decision on this one incredibly specific constitutional definition. Is the MFRC an organ of state? Now, the definition says it's any institution exercising a public power or performing a public function in terms of any legislation. The court looked at the facts. The minister almost entirely controlled the MFRC's mandate, and lenders had absolutely no real choice but to join. Because they were performing this vital public regulatory function under national legislation, the court officially decided yes, the MFRC is indeed an organ of state. And this quote right here brilliantly captures the court's unanimous stance on the issue.
It surely cannot be that government is able to evade the most solemn obligations imposed in the Constitution by simply resorting to the corporate form. That's a profound statement about modern governance. You absolutely cannot outsource government regulation to a private limited liability company just to sneak out of constitutional scrutiny. If you act like the state, you are bound by the rules of the state. Simple as that. Moving right along to Part 5, the power to delegate.
So even though the court agreed the MFRC was exercising public power, the top constitutional minds strongly debated whether the minister could actually hand over rulemaking power to them in the first place. Justice Yakub, writing for the majority, said the MFRC had to make rules to do its job. It was a necessary implication of being a regulator. But Chief Justice Lunga wrote a really powerful dissent. He pushed back hard, arguing that creating new substantive policy conditions is strictly the minister's job, and you can't just hand that over to a private body. To back this up, Chief Justice Lunga cited the classic legal maxim, delegatus delegare non potest. Basically, it's a fancy Latin way of saying that a delegate cannot delegate. His point was that the legislature entrusted this super important economic policy to a democratically elected, accountable minister, not to some unelected private company answering to its own board of directors.
Langa didn't just leave it at Latin phrases, though. He broke this dense concept down into a very practical 4-step checklist for lawful delegation. 1. Assess the impact of the power. 2. Review the extent of delegation and oversight. 3. Determine practical necessity. And 4. Weigh the identity of the delegator versus the delegee. Langa pointed out that even if the MFRC wasn't profit-driven, they still weren't directly accountable to the voters the way a minister is. When Langa applied the specific test, he concluded that several of the MFRC's rules were completely unlawful. For instance, creating that national loans register and giving themselves broad cancellation powers. Why? Because they didn't just enforce the minister's baseline rules, they created brand new, onerous hurdles for lenders out of thin air. In Langa's eyes, the MFRC was stepping way over the line and heavily onto the minister's toes.
All right, let's wrap this up with Part 6, the final verdict. So what did the Constitutional Court ultimately decide? The majority ruling came down in favor of upholding the MFRC's rules. They confirmed that the MFRC was acting as a public organ of state and that its rules were validly authorized. The majority felt the MFRC genuinely needed these rules to effectively police the micro-lending industries, so the delegation was valid by necessary implication. And as for AAA Investments complaining that the National Loans Register violated their right to privacy, the court basically waved it away and declared it moot. And you know why it was moot? Because in a twist of ultimate bureaucratic irony, right on the heels of this massive, years-long legal battle over the MFRC's power, the government just completely replaced the entire system anyway. The National Credit Act was passed in 2005, which set up a formal national credit regulator, ending the MFRC's reign entirely. All those rules they spent years fighting over, basically absorbed straight into the new legislation. But look, the precedent set by this case absolutely lives on, and it leaves us with a deeply provocative thought. As modern governments increasingly outsource their tasks to privatized entities, whether that's private prisons, private security, or private financial regulators, who is really watching the watchdogs? If we outsource the power of the state, we have to make sure the responsibility of the state follows right behind it. Thanks so much for joining me for this explainer, and I will catch you in the next one.